Mr. Comey, I'm wondering about your view about the relationship between the White House and the Department of Justice. This has been a tense relationship for much of our history, and certainly in the modern era, it's been a flashpoint. And you're right when you say that the president sets the law for the executive branch. But on the other hand, you've got the Office of Legal Counsel during the Bush administration, particularly with John Yoo and a few others who are writing memoranda on issues about interrogation policy that some view as torture, that were then picked up by the CIA and implemented around the world in various sites. When you look at how this has played out, what do you think the proper balance should be between the White House and the Department of Justice?
It's a great question. I don't know that it's possible to identify with precision a particular balance, but let me tell you the principles that I think should guide that. Whoever is the Attorney General and the Deputy Attorney General, those should be political appointees. I mean, I've heard people say in the wake of the U.S. Attorney firings that maybe we ought to have some different mechanism for picking our Attorney General. I don't agree with that. I think that the American people elect the President, and the President, whoever he or she is, should pick the Attorney General with the advice and consent of the Senate. But having been picked, especially those top two people, have to understand the unique nature of the institution that they run. And here's the way I think of it. I'm sure I'm making you dizzy with metaphors, but I go to the beach with my family along North Carolina Outer Banks. And between two sandbanks down there, there's an area where it's just open water, but the waves actually break because water's coming from the bay and hitting the ocean water, and there's this area of turbulence. That's where the Attorney General and the Deputy Attorney General stand. On one side of them is the essential political nature of the President, elected by the American people, going to carry out certain policy priorities. And because of the need to face that way, the Attorney General is duty-bound to carry out the priorities of the Attorney General. Attorney General Reno did more on child support enforcement. Attorney General Ashcroft did more on gun enforcement, because that was something that each of those presidents had run on. But they can't forget that behind them, the area that I call the Bay, is the essential nature of that institution, which is apolitical. The Department of Justice does tremendous good in American life, but it only does it because when you see an FBI agent, a DEA agent, a federal prosecutor, you see them as the good guys, and I mean that in a unisex way. You don't see them as the Republicans, the Democrats. I mean, I used to try to explain to people at Justice, the way all these great goods are accomplished is by men and women rising to their feet in courtrooms all over this country and winning cases you never heard of, civil rights cases, housing cases, drug cases. And they're able to win those because when they rise, the jurors see them as the good guys. And the sheriff, who may be a Democrat or Republican, it doesn't matter. He knows they are different. They are an other in American life. And I can't tell you how passionately I feel about this, because if you lose that, you've lost the ability of the institution to do such great good. And so the Attorney General and the Deputy standing there in the turbulence need to understand, I am at the interface between a political enterprise and a resolutely apolitical treasure of American life. And one of the ways to police that is to think about the difference between case and cases. The President can say, I want more cases on guns, and I told the American people if they vote for me, we'll do. But case, he may not go. And may not ask about a case, may not know about a case. And there's lots of other ways in which I'd protect that. And regularized communication, channeled through me when I was deputy, so I could write down what I discussed, is also very important. So it's a political appointment to run an institution that has to be apart from that politics.
Jack Goldsmith, who came in just before you did, started looking at some of the work that John Yoo had done when he was in the Office of Legal Counsel, and remarked, yikes, this is a mess. What went wrong there? What went wrong in the Office of Legal Counsel, where you had a series of memos that provided legal cover for actions, whether it's on interrogation or some other areas, that have now been looked upon as either poor work or just immoral? What went wrong there?
I don't know for sure. I think one of the most important considerations was that the circle was drawn very tightly. I don't know about anybody listening, but I benefit from people reading and editing my work and telling me what's crap and what I need to take out. And when you draw a circle so tight that there's only one lawyer in it and put extraordinary pressure on that lawyer, I don't mean by that to mean, illicit pressure, but the pressure that we all felt in September and October of 2001, and remove peer review and say we need this tomorrow, and then have people of a certain, intellectual predisposition, that it's a recipe for getting some work that may not be your best. And again, I wasn't there, and I don't know. I mean, I think I've met John Yoo one time. I don't really know the fella. But I think that combination of things, a predisposition, the circumstances, the lack of peer review, can produce, and all of us, can produce work that is not up to standard.
Apparently, these opinions were classified. In other words, they were not available to many people within the Justice Department or the White House or the Congress. Is that unusual to have a legal opinion that's binding within the executive branch and then classify it?
It is unusual, but it happens, but ought to be done as little as possible. Yeah. I mean, there may be, I don't know whether there may be things going on now, particular programs where the Obama administration has asked for advice, and it's a covert action of some sort, and so it has to be classified. But even within the constraints of classification, the circle can be broad enough to read in people with the appropriate clearances who could say, you know what, I think you ought to look at this. You might have missed that. And I think one of the strengths of OLC is, the Office of Legal Counsel at Justice, is that they share drafts typically with their clients. So they will send a draft to the general counsel of a HHS or to the Commerce Department for their thoughts and feedback, and they'll share it with others who may be experts in that area. I think one of the things that didn't happen in a lot of these areas of controversy was the circle was drawn so small that even the client agencies like State or CIA or NSA or Department of Defense who might have resident legal expertise were not in the circle. And no matter how well-intentioned you are, the more big brains you have on something, the better it's going to be.